Hello and welcome to the London Legal Podcast, presented by Hodge, Jones and Allen Solicitors. Our leading solicitors share their views on latest legal issues and developments, and how the law might affect you, because we care about righting wrongs and providing first-class personal legal services. So please enjoy this, the London Legal Podcast, presented by Hodge, Jones and Allen Solicitors.
Hello and welcome to this episode of the London Legal Podcast. My name is Chun Wong and I'm the head of the HJ Dispute Resolution Team. Today we will be discussing Inheritance Act claims for spouses and the interplay with divorce proceedings. I have with me my colleague Sarah, who is also a partner in the family team.
Hello everyone, and thank you for the introduction, Chun. My name is Sarah Harding and I qualified as a Chartered Legal Executive in 2010. I've practiced family law since 2006.
Thanks, Sarah. So to start things off, could you give us a brief overview of how you legally get divorced?
Well, the divorce proceeding is actually changing from the 6th of April 2022. You may have seen a lot of publicity about this being referred to as the no-fault divorce. However, insofar as this podcast is concerned, I will explain the position as it is now and pre-6th of April 2022. There is actually only one ground for divorce, and that is that the marriage has irretrievably broken down, and so one or both spouses have reached the conclusion that the marriage should come to an end. That irretrievable breakdown of the marriage has to be supported by one of 5 facts. Those facts are adultery, unreasonable behaviour, desertion for a period of 2 years, 2 years separation where the other party consents, and 5 years separation where the other party does not have to consent. To start the divorce proceedings, a divorce petition will need to be issued by one spouse who will be known as the petitioner, citing the fact upon which they wish to rely, for example, unreasonable behaviour. Unreasonable behaviour is often the most common ground which is used. That petition will be sent to the other spouse, who is known as the respondent. The respondent has to complete an acknowledgement of service confirming whether they agree that the marriage has irretrievably broken down. Provided they both agree, then the petitioner can apply for the next stage of the divorce, which is known as the decree nisi stage. The decree nisi is sent to the court and is usually obtained around 4 weeks later, depending on court backlogs. 6 weeks and 1 day after decree nisi, the petitioner can then apply for decree absolute. It is this document which will confirm that the parties are divorced.
Thank you for that summary, Sarah. A spouse is a category of people who can make a claim under the Inheritance, Provision for Family and Dependents Act 1975. This allows a claim where no reasonable financial provision has been made by the deceased, whether by virtue of a will or under the rules of intestacy, if there is no will. Sarah, can you tell us how such claims are affected by divorce proceedings?
Well, Chun, within any divorce proceedings, it is vital that financial matters are also resolved alongside any divorce proceedings. So part of the problem for spouses who divorce themselves without instructing a lawyer or obtaining legal advice is that they deal with a divorce and obtain decree absolute. And so they think that is over and that they are divorced. I've heard many people tell me that they are divorced, but they have no financial order at all. If financial matters remain unresolved, this leaves either spouse open to a potential financial claim in the future or a claim being made against their estate under the Inheritance Act in the event of their death. If financial matters are agreed, then it is usual practice for an order to be agreed dismissing each party's future claims against the other. This order also prohibits any future claims against the other's estate under the Inheritance Act. There are some exceptions to this, and that is where one spouse is receiving spousal maintenance from the other. In those circumstances, claims under the Inheritance Act remain open for so long as the other spouse is entitled to spousal maintenance, following which any claims under the Inheritance Act will then be dismissed.
And what about prenups, Sarah? Can they also exclude such claims?
Well, Chun, it's not possible to contract out of claims being made under the Inheritance Act, which you would be doing within a prenup, as that is a formal contract. However, it is possible to record the parties' intentions that they seek to limit claims being made in certain circumstances. It is also usual practice for a prenup to record that each party will make a will in the terms in accordance with the prenup.
Thanks, Sarah. To illustrate how this works in practice, I recently had a client who was defending an Inheritance Act claim by the spouse, and the deceased had agreed a settlement with her husband, and this was contained within a court order. However, the court order didn't take effect until the decree absolute had been obtained, but also before the decree absolute could be obtained, the deceased died. So the husband was still legally entitled to make a claim, as her will made no provision for him. And in the end, he actually received more than what was agreed in the divorce proceedings between the parties. And that's because the courts take into account the difference between divorce, where there are two surviving spouses to provide for, and death, where there is only one.
That's very interesting, Chun. It is very important to obtain decree absolute as soon as possible once an order has been made, because, as you say, an order does not take effect until decree absolute. In your case, as decree absolute had not been granted, the order had not taken effect, and so the husband's claims had not been dismissed, leaving the order incapable of enforcement. Again, there is a small caveat to this, and that relates to pension provision. One of the assets that is often taken into account in divorce proceedings is pension provision. The court can make an order sharing a pension on divorce. However, such an order, known as a pension sharing order, does not take effect until 28 days after the date of the financial order or decree absolute, whichever is later. Therefore, what we usually do is we have to wait 28 days after the financial order has been made before we obtain decree absolute. This is even more important if you are receiving the pension share, to ensure the pension sharing order takes effect before the final divorce is granted, the final decree absolute. What sort of considerations do the courts take into account when assessing an inheritance claim brought by a spouse, Chun?
Well, the questions that a court will ask are, firstly, has reasonable financial provision been made for the spouse? And secondly, if not, then what reasonable financial provision should now be made? In all Inheritance Act claims, the court have to have regard to all the circumstances, including the matters set out in Section 3, subsection 1. That includes things such as the financial resources and the financial needs which the spouse has or is likely to have in the foreseeable future, the financial resources and the financial needs which any other applicant has or is likely to have in the foreseeable future, the financial resources and the financial needs which any beneficiary of the estate has or is likely to have in the foreseeable future, and the size and nature of the net estate. In addition, for a spousal claim, the court also has to consider additional matters. For example, the age of the applicant, the duration of the marriage, and the contribution made by the applicant to the welfare of the family. The court will also have regard to what an applicant might have received if the marriage had been terminated by a divorce rather than death. This is what we call the deemed divorce test.
So, in a case where a financial order has been made but has not taken effect because we don't have decree absolute, but then the spouse has deceased, the court may have regard to this in an Inheritance Act claim.
Yes, the court can, but it should be stressed that this is only one of many factors the court will need to take into account when balancing the conflicting interests on the estate.
Thanks, Chun. If a property is held in joint names as joint tenants, then on death, the share of the deceased is passed to the surviving spouse. And if a property is held as tenants in common, then the deceased share will be distributed in accordance with the rules of intestacy or the terms of their will, if they've made one. So does that mean that a spouse cannot make an Inheritance Act claim on property held as tenants in common, as that has passed outside of an estate?
Actually, not so, because Section 9 of the Inheritance Act actually allows a court to take into account any property held, even those held as tenants in common, to such extent as appears to the court to be fair in all the circumstances of the case. And this is called the clawback provision. And this can apply to life insurance policies as well as properties. Thank you for your time today, Sarah. And I think many people are unaware of the pitfalls of not formalising a divorce in a timely and proper manner. Marriage and divorce are major life events which should prompt you to review the provision of your will or to make one. It's also vital for those that have arranged a divorce but do not have a financial order to take steps to formalise this, or at least obtain advice to avoid the risk of any future claim. Claims under the Inheritance Act are not straightforward for a spouse, and so having the guidance and support of a specialist solicitor is often beneficial and can help bring about a quick resolution. Thank you for listening today.
Thank you for listening to the London Legal Podcast, presented to you by Hodge, Jones and Allen Solicitors. To listen to more podcasts, follow us on SoundCloud or visit our website www.hja.net for interesting opinions and the latest legal information. Or if you need our help, call 0808 2780 216.